A 71-day jury trial taking place over 10 months.
Is no head, no arms, no legs, just a torso.
Just the torso.
And that's all they ever find.
We need to get a psychiatrist or somebody in here to help us understand that psychology.
The state has full control over the investigation and all the materials that are produced because of it. So it's not something that generally the defense could just figure out.
All right, Ryan, I got a question for you. Why do ladies who murder in Arizona always cut up the body?
You know, it's fascinating, right? We've done a lot of these shows. This is our third show with a woman as the accused murderer. This is now the second one, so 2 out of 3 are accused of cutting up the bodies.
Yeah, so that's a majority, and they cut them up.
Well, and here's another little tidbit for you. In fact, it's so common that when I was doing the research for this, you and I had decided what case we were going to do. They call this one the torso murder, right? Because that's all they ever found, was a torso. I got it mixed up with another one because there's another one almost just like it, also in Arizona.
That's a cut up body situation?
That is a woman cutting up a man's body and leaving only the torso to be found.
Yeah, of all the homicides that we've covered involving men who were the defendant,
Not
the murderer,
cut him up.
None of them cut him up. We need to get a psychiatrist or somebody in here to help us understand that psychology.
It's funny because I was thinking about this. Here's maybe a logistical reason for that.
Sure.
Harder for them to carry the bodies.
Yeah. Men are heavier.
Right. So in order to just carry it out, they gotta
chop them up.
Yeah.
Okay, and of course we're talking about Marjorie Ann Orbin.
Yes.
State versus Marjorie Orbin. This was a case that happened in 2004, September 8th, 2004, which ironically enough was her husband's birthday, 45 years old.
The
Victim, Jay Orbin. Marjorie and Jay, they had a small child together. They'd been married just for a short time. Actually, married earlier, divorced, still living together as a married couple. But divorced at the time. And Jay was going to be 45 that day, and instead his life ended.
Yeah.
Okay.
So a little bit about them, I suppose, right? Kind of their story.
Yeah.
Jay was a jewelry dealer early in his career, so he would have to go back and forth. He lived in Phoenix, but he'd go to Vegas, for these jewelry shows or whatever, and he would go to the show clubs, and he ran into Marjorie and fell in love with her. And she was a young dancer. He was in his 20s, I believe 25, 26 years old. Pursued her hard, wanted to date her.
Wanted to settle down.
Yeah.
But was Marjorie interested in settling down at that time of her life?
He was not. Apparently he didn't have kind of the assets or the things that she was interested
the money
in to do that.
Yeah.
So she broke it off. She then had an unfortunate kind of series of relationships.
Yeah, so these two, Jay wanted to get together with her more exclusively, settle down. She wasn't ready to settle down. They went their separate ways. She continued to dance in the show club scene for the next 10 years, I think. And during that 10-year period, she was married 6 times. So brief relationships, I guess, as they go. And Jay went his own way, continued to build his business. Again, he's in the jewelry business, traveling a lot, and actually made some pretty good money for himself, established himself as a jewelry dealer, traveled quite a bit. As I understood it, always traveled with a handgun in his briefcase because of the nature of the materials that he was carrying, some high-value stuff, so he wanted to protect himself. But eventually, Marjorie and Jay bumped into each other again. He, again, was frequenting some show club and saw her. And this time in her life, apparently, she was ready to settle down.
And my understanding, too, is that she had moved. So she'd been in another area of the country for a while as far as what she was doing. When all those things kind of fell apart, she came back to where it all started, back to Vegas. And that's where, they met back up and then...
Married and then settled here in Phoenix.
Yeah.
Yeah.
Yep.
They had a child together. I don't think their married relationship lasted very long. I don't have a lot of specifics on that. My understanding was that they were married for a time. They divorced, but were still living together, raising their child together. Jay was still traveling, still doing her business, and she was a stay-at-home mom.
And she claims later on that that was for tax purposes, that Jay had said, let's do that for whatever reason, even though that doesn't make sense to me as far as how taxes work. But
that's for a different type of podcast. Maybe we'll get a tax lawyer to comment on that.
Of course, lawyer.
Right. So, they're in this relationship, and Jay is traveling. It seems to me that she got a little bit bored, with the stay-at-home mom role.
She had stopped dancing.
That's right. Raising the child, and during some times when Jay was away, she would meet and spend time with other men, which unfortunately frequently is the case in these homicides. It's this kind of infidelity that leads to murder. So on one occasion, just before his murder, Jay was, I think he went to Florida. Due to some weather, he ended up coming home early. When he comes home early, he comes home and his wife or his ex-wife is there. Marjorie is there, and she's with another fellow by the name of Larry Weisberg, who, obviously is in some sort of side relationship with her. And then from there, Marjorie claims that Jay went on another trip, I think to Utah, and didn't come back.
Yeah, and forgive me if I mix up facts, because literally I was doing research on the other case for a little while, so correct me. But basically didn't tell anybody anything, just kind of waited until people in his life started to ask her, hey,
where's Jay?
Where'd Jay go? What's going on?
Yeah, and eventually, a missing persons case is established, and they're starting to look for him. They find his car in a neighborhood, parked somewhere, but there's no signs of Jay. Marjorie is at first cooperative with police. Later, as the investigation begins to, I'll say, focus on her potentially, she's less cooperative, and ultimately is not returning police phone calls, not allowing them to come over. Eventually, police find what's left of Jay. A hiker, somebody in the desert, locates this plastic tub, and inside that plastic tub is what's left of Jay,
which is no head, no arms, no legs, just a torso.
Just the torso.
And that's all they ever find.
One account also says that the keys to his car were in the plastic tub, and that's in part how police were able to identify his remains, because the key started the car.
There was a significant level of decomposition.
And really nothing there to identify him. There was some indication that he was shot with a single bullet, but kind of scant evidence and not a whole lot of ability to identify this. But eventually, again, police, through a variety of different means, are able to decide that that's Jay Orbin, and now this is a homicide investigation.
Right. Yeah.
And Marjorie now becomes a suspect. They do a search warrant on the home, and Marjorie is not cooperative with that search warrant, although, once you've got a warrant, police can go in and do the search. Apparently, Larry Weisberg was there, and he put up a bit of a struggle with police. They ultimately had to tase him during that warrant, is my understanding. So very suspicious circumstances there.
Another piece that they determined from the body or the torso that was found is that it had previously been frozen.
Frozen and then sawed up by a jigsaw is what they're claiming.
They determined it was a jigsaw that had cut his limbs off.
So I think the state's theory in this case was Marjorie shoots Jay, puts him in one of these chest freezers, and then once frozen, cuts him up. I don't know what she supposedly did with the arms and legs and head.
There was some indication later on. She was pointing the finger at
Larry,
Mr. Weisberg, saying that she really had no knowledge of it, only that there was one tub that had that in it, one tub that had the torso, and that they were hidden separately out in the desert, so she had no knowledge of where it was. Because that was a thing, the family turned to her at some point and said, Where's the
What's
rest of
deal?
them? Can we bury the whole
Right.
body? And that's where she kind of raised that, is to say she couldn't tell them where it was.
But not initially. I mean, initially she's claiming innocence, that she did not, that she wasn't a part of this. One of the, we've talked before about what a circumstantial case is. There's certainly some circumstantial evidence here. Some things that were used by the state were during the time that he's supposedly missing, um, goes to Home Depot or some other home store and buys these plastic tubs. They actually found the receipt, and the information on the receipt matches the barcode that was still on the tub.
I mean, that's a
Yeah.
pretty strong match, right?
Yeah.
And then they did find a receipt also for a jigsaw from about a month before.
So Marjorie then, of course, is arrested for this murder of Jay Orbin, and then she goes to trial.
Another thing that was presented at trial was her behavior afterwards, that she wasn't really involved in the search for Jay, but also that she had been just blowing through money.
Yeah, Jay had developed, as we said, a pretty profitable business. And one of the things that she's accused of doing is stealing from that business at or around the time of his death or following his death, withdrawing large sums of money. And so as a result of that, she's charged not only with the murder, but also 2 counts of theft and 2 counts of fraudulent schemes.
Yeah,
and
we
so,
talk about that, because that's an interesting thing where we've had that before, right? Where there was other charges that could have been brought, but they just brought the murder charge.
right.
And then there's issues with bringing in, facts or things without the other incident.
Yeah, and one of the lessons I think that hopefully people take away from this is that prosecutors are always going to be in a better position if they charge everything in the indictment. Doing so allows them to talk about all of the surrounding circumstances to the extent that those are additional offenses. It allows the state to talk about kind of the big picture. And that, of course, became an issue leading up to the trial. One of the contentions that the defense had was that those counts need to be severed. Okay?
Right. And we've talked about that before, multiple, cases, especially the baseline killer, where there were so many chapters, so many deaths, and they said, look, it's not fair to talk about one in the trial of the other because it taints the jury. And that's kind of the same argument that gets made here, is to say you can't talk about the thefts and, these accusations of taking the money inappropriately, because the jury's going to use that against me, as far as being charged with the murder as well.
Yeah, and this trial was a lengthy trial. It was a 71-day jury trial taking place over 10 months. Ultimately, Miss Orbin, of course, is convicted and she's sentenced to natural life in prison, okay? But she doesn't get the death penalty, but, is still subject or, in prison for life. And so on her appeal, she raises a number of issues about why her trial was not fair, why it wasn't, the right outcome, and so forth.
Get a new one.
Yeah, and so one of the things, and we haven't really talked about this before, but I think it's an interesting subject area, is the idea of third-party culpability, okay? When in a trial, the defense wants to blame somebody else, okay? They're going to say, well, it wasn't me that committed the crime, it was someone else, okay? So in this case, arguably, she wanted to lay blame on somebody else, likely this guy, Larry Weisberg, right? So I guess, Ryan, in your own experience, separating, from this case, talk to us a little bit about third-party culpability. What does that mean? And when can it be effectively used, perhaps, in a trial?
Yeah, so it's tough to be done correctly. It's tough to do it in a way that the jury catches what you're trying to do appropriately, because we've talked a lot about, burdens of proof and what, the defense is trying to do in a trial. So you say, okay, I understand that, Ms. Orbin is the one charged with this crime. My job as the defendant or as the defense is to introduce reasonable doubt, right? So I'm actually not required to prove that this other person committed the crime. All I have to do is raise enough. There has to be some evidence, some type of argument in order to say, I'm going to give you a third party to consider and say, why didn't the state tell you about this guy?
Mm-hmm.
Why didn't they talk about the investigation they did on him, and why ultimately that they decided not to charge him? And some of that might be relevant or not relevant, right? But generally it's going to be relevant. And then you talk about, you help the jury understand, or the judge, to say, look, I'm not saying that you have to believe and convict this person. All I'm saying is they didn't sufficiently do the evidence, and that their role in the crime, and that the possibility that they committed it is enough to have reasonable doubt about whether she did it.
Yeah, and that's a really good point. I mean, a third-party defense can be raised in just about any kind of case, or in lots of different types of cases. It doesn't just have to be a homicide. And what we're saying when we raise a third-party defense is we're saying somebody else did it, okay? Now, we do that in an effort to show that the state has failed to meet their burden beyond a reasonable doubt, right? That the possibility exists that some other person did it, okay? And in this circumstance, again, she's trying to shift the blame over to the other guy. And what she wanted at this level, and the court didn't give it to her, was a special instruction. We've talked lots about jury instructions and why they're so important. She wants a special jury instruction that says if you find that the defendant has presented evidence sufficient to raise the issue of third-party culpability with respect to the crime of first-degree murder, you must find the defendant not guilty of first-degree murder. Evidence of third-party culpability need only tend to create a reasonable doubt that the defendant committed the crime of first-degree murder. So she's kind of trying to change the law a little bit there by saying, hey, look, if you think we've raised enough of proof that somebody else did it, you have to find my client guilty.
And that's not the law.
And that's not what the law is. And the trial court didn't buy that, and the Court of Appeals did not buy it.
The court said that's a misstatement of the law, and the whole purpose is to not mislead a jury, and that could mislead a jury.
Yeah.
And why, though, I guess? Help our...
Right. The court says, well, first of all, that's a misstatement of the law. Okay. Yeah. That is not what Arizona law says as it relates to third-party culpability. And the court reiterates the idea that, look, if you're entitled to any instruction that is supported by the evidence, okay? But the appellate court, and I think the trial court also used the same reasoning, they're saying, look, you don't need a special instruction for this third-party defense. What you need simply is the reasonable doubt instruction, okay? And the reasonable doubt instruction basically says, if you are firmly convinced that the defendant is guilty, you must find the defendant guilty. If there is any sort of, well, if you are not firmly convinced, or if there is sufficient doubt that you believe the defendant is not guilty, you have to find the defendant not guilty. And I know that can be sometimes very hard to understand, right? How do I know, right? Or what becomes a reasonable doubt? That's what jurors have to decide in reading and understanding that instruction. So what the court says is, look, yes, defense can raise this issue of a third-party defense and blame somebody else, and to the extent that pokes holes in the state's case and makes reasonable doubt, well, then sure, you can find him not guilty.
Yeah, and part of the problem was the way that they had phrased their proposed instruction was, if you feel like we've sufficiently raised it, you must find her not guilty. And that's just not how it works, because that would mislead a jury to say, well, sure, they raised it. They talked about it. I guess we have to acquit her.
But a jury still has the task of weighing that evidence and deciding, is that enough to say that there's not proof beyond a reasonable doubt?
And yeah, that's what it came down to, I think, is it's got to come down to, and then the other piece of it is there's already sufficient instruction about reasonable doubt, which I struggle with. I mean, I feel like so few juries really understand reasonable doubt and how to apply it.
Of course, but that's the system that we have, right? So the other issue that she raises, and I think this is an interesting one, is the issue of severance, right? So you have these counts, the murder count in conjunction with the theft and the fraud schemes charges. Defense theory is that, look, those are separate crimes. They should be tried separately. The state's theory is that these things are part of a common scheme or plan.
Yeah, and again, we've talked about this before because it comes up so much,
okay,
right? Because there is the overarching principle that if you're going to convict somebody, it has to just be based on the evidence of that crime. And that the danger of having multiple crimes in one trial is that you're going to hold that, the proof of one case or one crime against them for the other one. And that's kind of just human nature. But there's so many rules and everything in place that talk about, okay, we're trying to protect against that, what we call prejudice to the defendant to do that. And the big thing that you're talking about here that they found to be very relevant, I guess controlling, is to say if it's a common scheme. And what we're saying is the motive for the financial, for the murder itself was the financial pieces, and that was just an extension. The murder itself was just an extension of her desire to gain control of the finance.
Yeah, it's part of it. We can't get inside of, Miss Orbin's head and understand what are all the reasons that she supposedly murdered her husband. But at least some of the proof is that she did that for the purpose of getting some sort of financial benefit through the theft and through the fraud. We know that a number of large cash withdrawals were taken from his business account, obviously with at or around the time or after the time that he had passed away, and she didn't have authorization to do that.
They were divorced.
So, if I'm the prosecutor, I want to say, look, of course this is part of the same common scheme or plan, because these are the side benefits. These are the objectives for, committing that murder. But as the defense attorney, I'm going to say, no, these are separate crimes. Just because she steals, just because she takes things allegedly, doesn't mean that she did it for the purpose of murder. How do we know that those things weren't used for, family expenses or other things? It doesn't necessarily flow from the idea that she's going to get rich based on Jay's murder. So you've got to think about those counter arguments and think, how do I, as a defense attorney, how do I adequately defend my client? Well, I'm going to sever those, right? I don't want the jury to hear about those things.
Yeah, and in most cases, that's what the defense would prefer to do.
100%.
Even though it's a lot more time intensive, you're going to be picking two separate, however many separate juries, going through the whole process multiple times. Again, going back to the baseline killer, they talked about how they wanted to do 13 different trials
Yeah.
on it, and they put them all into one.
Well, and as the defense, you have to be willing to work as long as it takes, right? If it takes 13 trials, if it takes 3 trials in Orbin or 2 trials, I'm going to do those.
It's about outcome.
Right, because I only get one shot. The state, of course, wants to consolidate everything. They want to make the defendant look as bad as possible. They want to do it all in one shot so that they can really make the defendant appear as guilty as they can. On the defense side, man, we want to separate those things. We do not want the jury hearing about the theft and the murder at the same time, because that invariably creates a motive for the murder, and it's additional circumstantial evidence for that crime.
It's not like it's just because we don't want it. I mean, that is a legal principle for defense and for criminal law in Arizona and in the United States. Is, like I said before, you're not allowed to use kind of other feelings about them or other acts against them to determine whether they're guilty of this crime.
That's right. The hard part, though, is the other acts are so intertwined with one another that it's hard to separate it, right? And what comes to mind, I guess, in this case is, how do you argue? Let's say that these cases were separate. These cases were tried separately. If you're trying to show the withdrawals from the business and the theft and the fraud, how does the murder not get discussed?
Well, and it would, right?
Right.
And that's another point that we've talked about too, where you say, look, we want to sever them, but many times they're going to use this 404B, and they're going to get those other acts in anyway. And in fact, this court said, we've already determined that all those other facts would be relevant in each other's trials, and so they would all come in anyway.
Yeah, and I guess that's what I'm helping our listeners understand, is the idea that how do you present that without ending up talking about the murder? Because part of what the state has to do is show that she did these things without his permission, right? Well, where was Jay? Did they get permission? Well, no, Jay's dead. He's cut up and he's stuck in a bin. You're going to talk about the murder. How do you not? Yeah. And then the other question, I suppose, is in the murder trial, can you avoid talking about the finances? I think that's a little bit easier, right? Do you have to talk about those financial things? You probably don't, right? Except that the state wants to get in the idea of motive, right?
Circumstantial evidence, right?
Yes, and when there's not direct evidence of her committing the crime, that financial gain is circumstantial. The idea that she's pulling this money out of the accounts after he's gone, you know, that
Before he's found.
before he's found, before the jig is up, as they say. All right, so that doesn't fly, and they've got to then try to do something else. One of the things that I thought was interesting, and I think our viewers hopefully will have a better understanding of this, is one of the questions I get from clients a lot of times is, why does it take so long? Why does my case take such a long time to go through the system? And so I think it helps to educate people about discovery. Okay, what is discovery? What are the rules behind it? And why is it so important? Maybe give us, a quick synopsis of that.
Yeah, I mean, the basic idea behind the rules of disclosure or discovery in criminal defense is to avoid surprise to the defense, but also that the state or the government it's pretty general, right? It's kind of the way they say it is that they are required to disclose information in a timely manner, right? In a reasonable time from when they receive it. Obviously, sometimes people get frustrated in their case that we don't have more quickly, but a lot of times the prosecution doesn't have it yet, or it hasn't been, like we're going to talk about expert testimony.
I guess to fill in a little bit more detail, when we're talking about disclosure or discovery, we're talking about all the evidence that exists in a case, right? From the initial 911 call to the police reports that are written to investigation that's done by experts or forensic folks or computer people or whoever, all of that work creates discovery. Anytime a witness makes a statement or is interviewed, or if there are photographs, I mean, depending on the complexity of a case, you could have a mountain of material to go through. And sometimes my clients ask, well, how come we don't get all the discovery right at the beginning of the case? I don't know the answer to that, except it doesn't all come in at the same time, especially in a case where somebody is arrested, booked, and charged quickly. It takes time for those reports to be written. It takes time for the investigation to develop. And we, of course, on the defense side, we're making our discovery demands from the outset of the case, and we want that material. But it can take weeks and months and sometimes longer for those things to be produced by the prosecutor's office. Now, there are rules that require the state to turn over its materials in a timely fashion. Likewise, the defense, if there's evidence that we want to use at a trial, we have a reciprocal duty to turn that over to the prosecutor's office. So during this pretrial phase of a case, after the charges are filed and before the case actually goes to trial, most of that time is spent gathering all of the discovery and then litigating certain motions that may need to be filed, for instance, like this motion to sever. But we're gathering all of this evidence over time. Now, what's interesting about Marjorie's case is that they had started their trial. They were still analyzing some computer data. And so when the data is finally disclosed, the states or the defense is like, hey, you can't use this, it's too late. But because the computer information that they sought to use wasn't going to be presented for months, remember this is a 10-month trial, the court says, it's okay, you got it in enough time.
Yeah, and that's often a good argument. I mean, if I told you that we started trial, and after we picked a jury, we're into trial, prosecutor drops, what was it, like 180 pages of data, an updated report from their expert. And I think that was part of the problem. They did have an older report, but it was just an updated report from the expert. It's not a bad argument to be like, Judge, we've already started trial. You have to disclose everything before trial. Generally, that is true.
Yeah, the rule is disclosure has to take place before trial. And here, trial, I guess, hadn't technically started. It took them a long time to get a jury, and the trial doesn't officially start until the jury is impaneled and sworn and they start calling witnesses. And so this disclosure is happening during jury selection. And, all the while there, once that disclosure happens, the defense expert has to have time to review it. And the judge says, well, we won't get to the computers for like 4 months. So you've got time.
Judge says, how long do you think your expert needs? And the defense says 1 to 2 months, I think, right, is what they said. And then it turned out they didn't need it for 4 to 6 months, actually, 6 months later before that testimony went on. I guess my response to that as a defense attorney is to say, I'm in trial.
Right.
I am in trial for that 6 months. You think I've
Right.
got time to be
Right.
hammering through these expert reports and sitting down with my expert and, coming up with a good defense on that side of it? I needed to know that before trial started.
Yeah, and it goes back to what you were saying earlier. I mean, the discovery rules really implicate or help to create a fair environment in which each side can present their evidence, and a jury can make a fair determination of what occurred. And it makes it much more difficult when one side or the other comes in late saying, "Oh, I got this extra thing that now you got to add to your presentation of evidence or figure out." It makes it much more difficult. And so, as defense attorneys, one of the tools in our toolbox, right, is to try to keep those late disclosures out. We don't want the state sandbagging us late in the game. That's not fair. It's not fair to my client. And unfortunately, here for Miss Orbin, the judge says, well, under the circumstances, I'll allow it.
Right, because we're talking about a thing called prejudice, right? Where you say the idea is that we don't want to have you sandbag or hide the ball, whatever you want to call it, till the last minute, give this evidence so that the defense has no opportunity to come up with a defense, and so that their case is prejudiced, right? It's not fair. And what the judge said in this case is that is overcome in this case because your expert had sufficient time to do everything that needed to be done. You had sufficient time to do everything that needed to be done. So no actual prejudice fell to your client, fell to the defendant.
Yeah, frustrating, but judges, often make rulings that we're unhappy with, and that becomes the basis for our appeal, right? That's what we'll do. So another interesting issue that came up in this one, and I don't think we've dealt with this before, while Marjorie was in custody, there was another inmate who claimed that Marjorie had made some incriminating statements to her, and the state wanted to use her as a witness. And I'll just read this from the opinion because I think it's really interesting. So, regarding Witness Hill, defendant argues the first instance of prosecutorial misconduct came during the testimony of Witness Hill. Hill met defendant in jail, where they were both prisoners. Hill entered into a plea bargain in which she agreed to testify against defendant. After she entered the plea, Hill told investigators defendant told her she acted alone when she murdered the victim, then cut up and disposed of his body. At trial, however, Hill testified the majority of what she told investigators was a lie, that she never heard defendant make any admissions or otherwise say anything about her case, and that she lied simply to get a better plea deal. The prosecutor thoroughly and aggressively impeached Hill with her prior statements almost from the very beginning of her direct examination. Defendant argues that the alleged prosecutorial misconduct occurred not during the prosecutor's examination of Hill, but during a break in Hill's testimony. She argues that during the break, the prosecutor threatened Hill with perjury in an effort to intimidate her and make her change her testimony. The prosecutor argued to the court that he was merely kibitzing with Hill's counsel and not speaking to Hill. So, what a disaster, right? So, this gal Hill claims that in the jail, Marjorie makes some statements, incriminating statements to her. She gets a deal from the state. And this is sort of a cautionary tale to the prosecutor's office, right? Don't enter deals with people who are going to flip backwards. I mean, because this woman then got whatever benefit. Well, I don't know ultimately what happened with her plea, but, when it came time to fulfill her end of the bargain, she goes in reverse and says, I was lying.
Fascinating, right? Because already jailhouse, what they call jailhouse snitches, right? Or jailhouse
snitches get stitches.
Yeah.
Right.
They're just not favored, right? Because they're just kind of, it seems like you can always find an inmate that'll say whatever the state thinks their theory is, right? If they want to do it. And your defense has every opportunity to cross-examine them and to, lay out those type of motives to the jury. But what do you say? The bell has been rung. You can't unring the bell as far as they're saying that there's a witness here who says exactly the theory that the state is advancing. But it's pretty unusual then to actually get them on the stand, to go through that whole process and then just completely.
Like, yeah, I was lying. Well, you remember in the Baseline Killer, there was the fellow from the Midwest who admitted to all of the Baseline Killer crimes just to get out here and get out of his own thing, his own circumstances, only to come to find out that, yeah, I'm not the guy that really did it. I just wanted to take a trip out west. I don't know. It's hard to get into the head of inmates like that, and I'm sure their circumstances are difficult, and they may do things for certain reasons, but it certainly would be a very frustrating thing as a prosecutor. And then, of course, Marjorie objects and says the whole thing affected her trial.
Well, yeah, interesting too, because after that happens, they take a break, and prosecutor makes some offhand comments. Well, what happens to people who commit perjury? Something that the prosecutor said, basically threatening the witness that they're going to get charged with a new crime for changing their story back or changing it, on the stand. And you can look at that two ways. You can say, well, it's the prosecutor trying to make sure they stick to the correct story, or you can say, no, they're applying pressure to try to get them to say what they want them to say.
Yeah, and again, did the prosecutor really need that type of evidence? I don't know. I wasn't there. I don't know how strong they thought their case was mid-trial. It's always hard to know, how far do you go in the proof that you're trying to present? Where do you stop? And what's funny though is that Hill wasn't the only witness. There was another one.
Another jail.
Yeah. I'll read this next paragraph. Defendant next argues that the prosecutor engaged in misconduct when he failed to disclose benefits witness Johnson received in exchange for her testimony against defendant. Johnson was another former jail inmate who testified that defendant admitted she murdered the victim, froze his body, and cut it up. Okay, so either Marjorie is just running her mouth in the jail testifying to all these people, or there's kind of this bandwagon where, people say, well, I'll say whatever you want to get some benefit from it. The argument was that the state failed to disclose certain benefits that, that this Johnson had received. And in terms of what that benefit was, it was, transportation to and from the hearing. It was food. It was sort of minimal things that really didn't amount to a whole lot. It wasn't like she got a better plea deal or her case was dismissed or something like that. The court didn't buy this one either. They said, well, those aren't necessarily significant benefits. And we also know that you knew about them. Like, this isn't just a total surprise to you.
And it was interesting, though, because the prosecutor sometimes gets guilty of saying, well, I didn't tell you about it because it wasn't relevant. Instead of just telling you about it and letting you decide whether it's something to raise, right? Because what they said was, in the end, they did find that, yes, the prosecutor did make some type of offer to Johnson, but Johnson didn't accept it. Mm-hmm. So that the way that the prosecutor worded it to, the judge was saying that she has received no benefit for doing the testimony without disclosing, yeah, I did make her an offer to do this, but she refused that part of it. She still,
and that seems to add to the credibility of the witness, doesn't it? Like, if they say, well, I'm such an honorable person that,
I'm innocent.
Keep your money.
Yep.
I'll do this for free.
That's right.
Yeah. And the court also found that there was really no prejudice that was suffered as a result of that.
Sometimes that testimony can be precluded, right? Where if you find that there was some type of prosecutorial misconduct in getting testimony, I'm mixing these up with the expert testimony, but with the expert, going back to kind of the expert testimony thing, we do see that get precluded. So I guess where it could have worked itself out in this case was, that the judge said, yes, you already knew about this expert. You already knew about their previous report. The judge could have said, I'm going to preclude the newest version that got given to you after trial started or after jury selection started. Judge could have done something like that, and they could still use the expert, could still use whatever, reports or testimony they give them.
Yeah, going back to the discovery idea, discovery violations, like if things come in late or whatever, can be handled in a variety of different ways. Those are what we call sanctions, right? So if a party violates discovery rules, the court has a number of tools that they can apply. They can say, well, okay, we're just going to continue the case. You don't have to go to trial yet. We'll push the trial out. You can have time to review the discovery, and there's that. In other instances, if the discovery violation is a little bit more egregious, the court can go so far as to preclude that evidence. They say, well, it's not disclosed in a timely fashion, so you can't use it. And that can be super frustrating, especially if that proof is important proof, right? That the state wants to rely on. So it's important for both sides. And as a defense lawyer, it's super important for me to disclose things, right? Prosecutors have a heavy burden of disclosing all the time because it's their case. They have the burden of proof. But the defense cannot rest on its own case either, because if there are witnesses that we want to call, or if there's exhibits that we want to introduce, or photographs, or whatever, reports, scientific information, we have that same duty to disclose. And, certainly I've seen cases where defendants on appeal will argue that, well, my lawyer didn't do the things that they were supposed to do. They were supposed to investigate and disclose a certain witness, but they didn't do that. And that can be, ineffective assistance of counsel and other things that gets raised. So it's such an important duty. And I think, sometimes we don't give it enough treatment when we talk about it.
But those duties are slightly different, wouldn't you say, between the prosecution and the defense?
100%. Well, it's the same general duty, right?
Right.
But the state,
How it works.
But the state has that burden of proof. And so anything that they want to use to show that my client committed this offense, they have to disclose it.
Well, and I think that's one of the big differences. Anything that was used in the investigation, even if they don't plan on using it, they have a duty to disclose to the other side. Whereas the defense, it's only things that if we want to use in trial, we don't have to disclose everything we've ever done as part of the defense. It's only what we potentially could use at trial.
And I appreciate that clarification because you're right, including on the state side, exculpatory evidence. I have a case pending right now. I just mentioned this to you the other day. It's a case involving allegations of aggravated assault, a dangerous offense. And the state just disclosed to me some DNA that is very favorable for my client, that shows the victim's DNA is not on my client's vehicle, which was supposedly, the weapon that caused the crime. And the state disclosed that to me. I'm grateful that they disclosed it to me. And the law requires them that they disclose that. But how many cases have we heard where the state sits on and hides evidence? I mean, the prosecutor could have just as well kept that from me.
Said, oh, I don't think it was credible, or I don't think that it was...
Or just not told me that.
Just not tell you about it because nobody's ever going to find out potentially. But then you hear these, there are stories where later on in appeals and whatever, you find that information that the prosecutor had at the time and did not disclose. That is a massive violation. Well, lose their law license, all kinds of...
I think there are few things in the law worse than that. A prosecutor's duty to disclose unfavorable evidence is so, so, so important. And it goes back to, we've had discussions about Juan Martinez and other prosecutors. Incidentally, Marjorie Orbin's prosecutor, not Juan Martinez. It was not a Juan Martinez case. But that idea that prosecutors have the duty to do what's right. I think in our initial podcast, we had some discussion about the prosecutors and their duty to do justice, right? When we were talking about Mr. Martinez's straying from that duty. They got to do the right thing. It's not just about getting convictions, okay? Now, setting Orbin's case aside, right, that general duty to do the right thing, to disclose unfavorable evidence is so important. And that, again, plays into our role. We have to push for that. We have to make sure that those things happen, because if we're not there, guarding and forcing the state to do those things, sometimes people get lazy.
Yeah, I mean, you see these prosecutors kind of get lost in their own world of thinking, well, I know the guy did it, and so I don't want to present this unfavorable evidence that could make it harder for me to convict them. I mean, it's just so fundamentally unfair in that situation, and people might disagree because they're like, oh, you're protecting somebody who's guilty of something. The state has full control over the investigation and all the materials that are produced because of it. So it's not something that generally the defense could just figure out or just find. They are reliant on the prosecution doing the right thing and following their duty.
Yeah, and again, we have to hold them to that, and we continue to fight that fight. And yeah, we represent clients who they may have done it, they may be guilty, but that doesn't change the state's burden and the need to do things in the right way. So, good lessons, I think, from Orbin. Again, I don't understand the obsession with women murderers who cut up the body. Need to do some digging on that, figure out that. But it does present some good lessons for us on discovery and disclosure and, the need to hold the state to that burden. So,
absolutely.
All right, another one in the books.
Yep.